discussion so that to prove really you are listening. Now, I'll be discussing with you again as a continuation to suffice my discussion last time on the origin of laws. Okay, so these are positive laws, or as which are actually originated from the natural law itself. Basically, laws are rooted on the natural law because religion may not be a reason for criminalizing certain act. Okay, so our example last time was killing of a person. What is our reason why we consider killing a person as illegal? So we should not reason in a manner in which we quote it from the Bible that it is in the commandment of God. Okay, so the reason behind it is because basically killing a person deprives his right to life, and it is a natural right which cannot be um, done by convention. So it is innate in a person that they have all the time. That those are natural. Okay, so we go into the Philippine bar 8-bar subject. Lately there are modifications, but I'll go into the original that they followed for several years. Okay, lately they combine some subjects here, like transferring tax now into a subject under political law. Okay, but originally it's not. Okay, so these are we call it as the standard. Every bar chairman sometimes makes modifications, but for several years this is the standard that they follow. So we go into the first one. We have the political and public international law. That's one subject in the morning. Okay, includes constitutional, administrative law on public officers, election law, public international law. Okay, labor, we have social legislation in the afternoon, covers labor standard, relations, social legislation including GSI, SSS, PhilHealth. So what are those subjects under that laws that I have mentioned under political law and social legislation? So under political law, we have constitutional law. What covers under it? Of course, you have to study there the 1987 Constitution. Okay, its understanding, its history, and includes there the Bill of Rights, which is very important. Okay, and includes civil and political rights of individuals, and in fact it is the most important part of constitutional law, the Bill of Rights, because these are rights that the state should protect. And then on this structure we have the powers of government. We have the executive, legislative, and judicial. These are the three branches which is also discussed along the way on different um, different sections or articles. Okay, so check and balances. These are the separation of powers of between the three branches. Okay, amendments and revisions of the constitution, and then judicial and political question doctrine, that is important topic under the constitutional law. And those subjects, I believe, will be discussed thoroughly in your subject, the Philippine Constitution. Lately, there is a subject because of the innovations of the government, delimit now the general education subjects into 8. Before, there was Philippine Constitution in all students in college prior to finishing any degree programs. Okay, but right now that Philippine Constitution, including land reform and history, are merged into one subject, and that is the con- Philippine history and no Philippine readings and Philippines history. It's one of the eight general education subjects offered in college. Um, all the faculty in the Visayas, there were only few of us who underwent that training in Lasal for 2 weeks. Lasal, Manila, of course. We stay there for 2 weeks on 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 a training, okay, to teach that subject. And in fact, we are the one crafting the syllabus of that. Okay, so I trained also faculty of Cebu Normal on that subject, but I was now teaching on different because I was assigned in was now assigned in public governance, and we teach now um, contemporary world. Okay, but originally that is the subject that belongs to our department, and because of the merging now of different subjects, so it was given to history because the title is history, reading of Philippine history. Okay, so we are the one crafting its syllabus, and they are the one following what we have crafted. I even train all of the faculty in Cebu Normal to teach the subject. Now, well, it's about constitution, but in your case, it's a major subject. You will have your constitution, which um, for many years I have been teaching that in Cebu Normal, including other degree programs. Now we go into another subject under political law. We have the administrative law, and what are subjects or topic that will be covered under it. We have the administrative agencies, okay, and these are departments under Philippine government, and there is actually a law that they have to follow, otherwise they will be liable under civil service rules or even criminal charges if they're not going to follow what is in the administrative law. It's also another subject, and I recall I was teaching this one in both in the graduate school and in undergrad under degree public administration. So what are subjects that will be covered under administrative law? So we have the administrative agencies. These are the different departments of the government, headed of course by the president. Okay, as chief executive, he has the prerogative to restructure, create offices and department that will address the problems or enforce the law passed by Congress. As executive branch, he has the power to make adjustments to fully implement the law and the constitution. So apart from that, the president has the power to make or create different departments. So it's headed by a department head, which is an alter ego of the president, acts as like a president. Of course, in the department, okay, to name a few, we have Department of Education, Department of National Defense, and so on and so forth. So, in my class, I've been teaching um, departments based on reflected in their fingertips. Okay, so to name a few, as I mentioned, okay, we have these fingers, right? So what department that this one represents? This is a department of justice. Why? When you commit a crime, all you have to do is to make a thumb mark to prove that, to prove identification, to identify that you are really the criminal, or in fact, in the SOCO or the scene of the crime, they're looking for fingerprints. No one has the similar fingerprints. Our fingerprints in the thumb is similar to a zebra stripes. The mother certainly knew whether that zebra below is his offspring because of the stripe. Similar also to human being, we do not have similar, even in the entire world, we do not have similar um, thumb fingerprint. So that's a Department of Justice. How about this one? What department that this represent? Department of what? Department of Education. Why? This will teach. Okay, teachers use this one to point a word in teaching. Department of Education. How about this? What department? Department of Health. Why? They use this one in cleaning their nose. So this is Department of Health. What else? This one. What department this represent? Department of what? Department of Finance. Look at the accountant. When they count the money, they put saliva, then count the money. They use saliva in counting. They use this one. They put saliva sometimes and then count money. How about this? What department this represents? Department of Interior and Local Government. Well, it's up to you how to interpret that. Okay, let's proceed. Um, Now we go into the, okay, it's part of also in the subject administrative law is the discussion on the role making power or the quasi legislative. Okay. This is very complicated. In fact, in my discussion, we spend so much of our time discussing and understanding by giving different examples of the quasi-legislative. Although there are three branches, right? To give you an idea of what is this role-making power, the three branches of the government, executive, legislative, and judicial. The executive branch, which create different departments, belongs to the executive branch. Even if it's an executive branch, but if there are laws that are not clear, it has the power to make law itself. So take note, it is an executive branch, but it has a power to make other laws. Okay, we call it as the rule-making power. It simply means the quasi-legislative power of the administrative branch. So the administrative branch, the department, let's say Department of Education, the one I mentioned, although it is an executive branch, which means it only executes the law, the constitution, and the law passed by Congress. But if that law is not clear, it has the power itself to make law, okay, to clarify. Sometimes the implementing rules may even be a product of quasi legislative power, but they do not have the power to actually implement the penalty. Okay, so they can make a law to clarify. Okay, so it should not, there's a principle that the water cannot go beyond the source. So you cannot make a law higher than the law itself creating you. So if it is not in the Republic Act, which is the law, okay, um your law that you're going to create, which is not clear, should not go beyond. Okay, so we go to other topic under administrative law. We have adjudicatory power. Okay, another power also of the executive branch, like the department, the offices that I have mentioned. Although it is again an executive branch, but it has the power to interpret the law, or what we call it as quasi judicial function. Okay, so So it's so confusing, right? So we have the principle of checks and balance, meaning the executive branch can be questioned. Their decision can even be challenged by the Supreme Court, whether it is in accordance with the Constitution. And therefore, if it is not, then it will be declared as unconstitutional, right? Now, um, they should not go beyond or encroach other powers, but they have the checks and balance. To limit in a democratic country, we should limit the powers so that they will not abuse. So, in the branch, executive branch again, if the law pass that, let's say, a public act, and it will be executed by a department, and if the execution itself will not suffice the law, they can actually make a law itself to clarify. What do you call that power of the executive branch? It's called the role making power, or simply means a quasi legislative. Okay, so another is same also. If the executive branch, there are violations of the laws that they pass under a quasi-legislative power, it can also function as a quasi-judicial or simply adjudicatory power. What do you mean by quasi-judicial? It When we say quasi, it's similar to. It's not really judicial because judicial branch belongs to the other department, the judicial power, the Supreme Court, and courts under it like Court of Appeals, Regional Trial Court, and Metropolitan Trial Court, and Municipal Trial Courts. So it is not a court, but it can interpret based on the laws they pass and under quasi legislative, or if the law itself is not clear and it has that power to interpret. Now, we have a principle in the government that, well, there's a what we call as the presumption of regularity, meaning all acts of government are presumed to be regular or legal. Example is arrest of the police to certain criminals. You cannot simply charge the police for illegal arrest. Okay, they always make it sure that their defense would be that it is in accordance with the law. So it is presumed to be regular. So nobody can question it. In fact, the court sometimes favors the police officers doing that under the principle of presumption of regularity. That also applies to different departments. They can be presumed as performing their duties in accordance with the law, or presumption of regularity. Okay? Now, if there are abuses, what should the court do? There can be questions in the civil service. Take note, government officers are civil servants. A violation of administrative law can be challenged under the civil service. If it is a personal act or a violation of a criminal offense, performing it outside of their duty can be a reason for a personal liability, not necessarily civil violation of civil service rules, but it could be a criminal offense. It may even be that a person, a government officer, can be charged both um, in the regional trial court, or even in the ombudsman, or in the civil service. Okay, so if the person is a government employee, the ombudsman. Okay, if it's a criminal offense. Okay, or it could be even be um, administrative offense. However, if the court acquires jurisdiction, let's say ombudsman acquires jurisdiction first, then civil service may not may refer the case to the ombudsman. Okay, why? Because we have a doctrine of the court that has acquired jurisdiction first excludes other court. Okay, although civil service is not a court, but it is considered as a quasi court. So any judicial bodies, okay, that acquires jurisdiction of the similar case, okay, all not really the same, but apparently similar, then that excludes the other. What happens if you submit both similar case to different courts? You will be held liable for forum shopping, okay, and the lawyer will be criminally, administratively liable. That may be dismissed, and the lawyer will be punished for violation of the forum shopping. A forum shopping is a certification that you did not file the same offense to the same to different courts. Had you known one, you have to inform the court of its status. Failure to do so will be will result to a dismissal of the case or a possible if done deliberately, then the lawyer will be held administratively and criminally liable. Worst is it will be dismissed without prejudice, with prejudice, meaning you cannot refile it anymore. It automatic an outright dismissal. If without prejudice, if the decision is without prejudice, you can refile. Now we go to, I don't know if you understand what I'm talking. It's highly technical because those are subjects in the higher years as you studied law. Since you are still in your introduction, so it's better to understand only the basic. Now we go into the other doctrine under administrative law. We have the doctrine of the exhaustion of administrative remedies. The doctrine simply means that you have to exhaust first all possible remedies under the executive branch. You cannot go to court or jump into other branch which is judicial without first exhausting all administrative remedies. What does it mean? You know, there are three branches, okay? I'm sure this will be repeatedly discussed by your professors on the different departments: executive, legislative, and judicial branch. Judicial branch is only for to interpret when you do not have any remedies under the executive branch. You cannot go into it because of the separation of powers. You all have to do is to exhaust first your remedies, meaning you have to, if you failed in the lower body, like for example a case of students, okay, or let's say um yeah, students, for example, a case against students and let's say your professor, okay, you have to exhaust first all remedies, like go first to um, dean of student affairs, the president, and then judicial. You cannot simply go to court because of the principle of exhaustion of administrative remedies. Okay, the court will remand it back to the head of the agency to determine the issue. Okay, so that is the principle of the doctrine of exhaustion of administrative remedies. Now, judicial review of administrative actions. What does it mean by judicial review? Only when the administrative agencies fail to ascertain, or if you think there are injustices, that's the time that you can seek remedies to courts. Another laws under administrative under political law, we have the law on public officers. What are topics that will be covered on law on public officers? The nature of public office, the qualifications and disqualification, appointment, term of tenure, okay, removal of office, disciplinary actions, liabilities of public officers, and possible doctrine of operative fact. Okay. Um, we go into the nature of public office. In Article 9, right? Article 9 of the Constitution, public office is a public trust. What does it mean? You have to make it sure that the people will trust the public office. Otherwise, they will not pay anymore their tax, or worse is they are going to rebel if they will not trust our public office. Public office is a public trust, meaning at all possible scenario, you have to make it sure that the people will trust the office. In what way? Like, well, it is found in the um, Code of Professional Responsibilities of Officers. So for public officers, there are 8 rather. There are 8. So you have to look into it. What are the 8 um, doc, principles of government employees? Okay. One of which is non-partisan, and then the last is simple living. You should know others because I'm going to ask you next time we meet what are those 8 um, standards of government employees. So to prove to so that people will trust the office, you have to live a simple life. In fact, in times of necessity or disaster, when there is a public need to, like calamity, it's is the instantaneous display of wealth is even prohibited. You cannot simply post in Facebook the food you eat while others are suffering. Okay, especially if you are a government officer, or post in Facebook displaying all your jewelries. What is allowed is only probably one jewelry. Having it so many maybe make us doubt into the source of that jewelry. And there's even safety measures of government to so that the people will trust public office. One of which is the declaration of assets, liabilities, and net worth, or SALN. They define SALN sometimes for government officers. Secret ang laman nito. SALN, secret ang laman nito. Or meaning they do not expose what they have. They will not allow the public to examine the source of their wealth, and that is prohibited. There are many officers who failed to submit. Okay, to name a few, if you have even a Supreme Court, okay, Chief Justice, in fact, who failed to declare the assets and liabilities, and net worth. They cast doubt, so people will not trust them. So what case that they may be facing? Betrayal of public trust. People will not trust them because you have so many secrets. You did not disclose your properties. So the purpose of that is to make it sure that the money you have reflects your income. The assets you have reflects your income. If you are just a guard and then you have so many properties, that will cast doubt as to its source. Okay. Or even a government employee who keeps on going to a casino or any places where they have to draw a bet like sabong, um, that may be that may be a case, a source for a criminal case filed against them. um, Term and tenure and removal of the office, well, there are provisions where can be, when can be removed, okay, or they may be, um, when would their term ends. Of course, their office is based on what is in the law, right? Like president, there are corresponding years that they should serve, the tenure, um, the number of years that they have to serve, or how many years can they run again for another term, and then how can they be removed, like death or resignation or even removal. There are reasons, or when can they be removed. Disciplinary actions, it also discussed in law on public officers, when can they be suspended, part of which is the distinction on the jurisdiction of the ombudsman on suspension, like preventive suspension as distinguished from a suspension as a penalty. Okay. So another is the liabilities of public officers and doctrine of operative fact. Doctrine of operative fact simply means that if at the time when it was allowed or legal, those acts that are declared to be illegal later cannot um, cannot simply operate retroactively. So meaning, let's say there are projects spent and the money, the source of that was later on declared to be illegal, like PDAF or DAP. That law or that the decision cannot retroact and make the person liable. That is what we call as doctrine of operative fact. That applies to PDAP or DAP. Okay? So